Hello friends, welcome to my channel. Today we will discuss the overview of the Evidence Act. The Indian Evidence Act originally passed in India by the Imperial Legislative Council in 1872 during the British Raj. The term evidence derived from the Latin term evidere, which means transparency, clarity in presentation, and capacity to establish the claimed fact. Once, an English philosopher, Jeremy Bentham, has said that evidences are the eyes and ears of justice. In other words, the role of a witness in criminal justice system is very crucial because of their testimony decides the future of the trial, and without their assistance a fair trial cannot be achieved. As per the Section 3 of the Indian Evidence Act, evidence means and includes oral evidence as well as documentary evidence. All statements which the court permits or requires to be made before it by the witnesses are oral evidence, and all documents, including electronic records produced for the inspection of the court, are documentary evidence. Arbitration is the procedure which allows parties to resolve disputes outside of the court. Such proceedings are usually voluntary and consensual between the parties. So, there is no applicability of the Evidence Act. On the other hand, affidavit binds a person on oath to state the truth, but it is possible that the person is making a false statement. So, affidavit is not treated as evidence only if the court so orders for the sufficient reasons. In both civil and criminal proceedings, the law of evidence has a number of purposes. However, due to the different nature of civil and criminal cases, the rules applicable on them may be different. The main difference is civil case is the one instituted by individual, while penal prosecution is instituted by the government for the purpose of securing obedience to its laws. Evidence is based on facts. So, when a fact is proved, the court gives judgment in favor of a person. When a fact is disproved, no further question arises as to its proof. When a fact is not proved, then it implies that by adding further evidence, it can either be proved or disproved. Evidence Act is not exhaustive as many procedural rules are mentioned in the Civil Procedure Code and the Criminal Procedure Code, and all penal provisions are mentioned in the Indian Penal Code. So the Evidence Act is not complete act. So that's all my friends. Hope you like my video, and please like and subscribe my channel so it can reach more people. Thank you.